Hello, and welcome to the 2022 Virginia Festival of the Book, presenting Who Owns Your DNA? I'm Jane Kulo, Director of the Virginia Center for the Book, a program of Virginia Humanities. Thanks for joining us. A couple of notes before we begin. Please share your questions for the author using the Q&A tab on Zoom. This event has optional closed captioning, which you can turn on and customize at any time with the tab at the bottom of your window. If you haven't already read today's book, we hope you will. For details about how to buy it from a local bookseller, visit vabook.org, where you can also explore the schedule of upcoming programs and watch past events. While you're there, please consider making a donation to support the festival's ongoing work at vabook.org/give. Thanks to our bookseller for this event, Fountain Bookstore in Richmond. Now, I'm pleased to introduce our speakers. Jorge Contreras, author of The Genome Defense, received his law degree from Harvard and teaches intellectual property, science policy, and genetics law and ethics at the University of Utah. He has been featured in several publications, including Science, Nature, and on NPR, BBC Radio, and more. Welcome, Jorge. Cathy Hwang is the Baron F. Black Research Professor of Law at the UVA School of Law, where her research and teaching focus on business law. Her work has been published in Columbia Law Review, Virginia Law Review, and Northwestern University Law Review, among others, and 3 of her articles have been voted by business law professors as among the top 10 corporate and securities law articles of the year. Thank you all for joining us today. Jorge, Cathy, it's all yours.
Thank you so much, Jane, and thank you so much for having me. So in the spirit of my questioner, I will start with a little bit of introduction, and then I'll tell you about the format of today's event. So in 2013, actress Angelina Jolie wrote an op-ed in the New York Times about her decision to undergo a preventative double mastectomy after learning that she carried the gene that greatly increased her risk of breast cancer. So she was lucky enough to be rich enough to undergo the genetic testing, but are the rest of us able to do that? So Jorge's book is in part about this question. He follows AMP v. Myriad, the path-breaking civil rights case about the issuance of patents for human genes to biotech companies. In it, he considers who gets to own our genes and what the implications of corporate ownership might be. If genes are set free, so to speak, could more people take advantage of the type of life-saving genetic testing that Angelina Jolie got to use? So I would say that I have read this book. It's and I have a copy right here, which I will sneak in front of my face. I actually own 2 copies, but it's a wonderful, important, careful book. Before I was a professor at UVA, I served on the same faculty as Jorge for several years, and I have to admit that I never even knew he was working on this project. So to me, the Jorge Contreras of my knowledge was a respected colleague known for his vast knowledge of CRISPR gene editing, and a beloved teacher who had students following him around the hallways, who talked about his goofy, nerdy teaching demeanor. And it was a really wonderful surprise as I read this book to learn that he had a double life as a trade book author, and wrote beautifully and knowledgeably about one of the most important questions of our time, specifically, who owns the building blocks of humans? So today's format is kind of, we'll have 3 parts. So first we'll ask Jorge to read a passage from the book. Then I have a bunch of questions for Jorge about the book. And throughout that, I invite you, and after that, I invite you to put your questions into the Q&A. So that we can also, you'll have a chance to also talk to Jorge about your questions about the book. If you are wondering what my favorite parts of the book are, I will say that there are some very amusing notes in the back, and also some interesting definitions. So I invite you to refer to the back, which I think is very hilarious. All right, with that, let me turn it over to Jorge.
Great. Well, thanks so much, Cathy. It's a real pleasure to be here. Thanks to the festival organizers for inviting me and for choosing this book to be one of the books that's featured here. It really was a labor of love to write this book, a project that I undertook over about 8 years not nonstop, but certainly for a substantial amount of time over those years, and did a lot of work, including interviewing almost 100 people who were featured here, from lawyers and scientists and doctors and judges to the patients themselves who were affected. So that was really gratifying. And I have to issue a disclaimer at the beginning. Like, this book is really their story. I mean, I'm the messenger and very pleased to be that, but we wouldn't be here without them. It's really about their amazing stories. So just could you remind me again about did you want me to read a part of the book now, or is it something different?
So according to the festival organizers, it would be lovely to hear your sonorous voice speak to us from the book. So yes, you are invited to read a passage from the book.
Thank you. And we did obviously discuss this before. I just wanted to make sure I was doing this at the right time. So I'm not going to read the very beginning of the book. I picked a passage from probably 2/3 of the way in, but I think it's very understandable to people. And it relates to a person who we've met earlier in the book. Her name is Kathleen Maxian. She is a woman who has the deleterious BRCA gene mutations that Cathy talked about at the beginning, and was not tested in time. She was not tested for a variety of reasons about eligibility for getting the test, insurance coverage, and so forth. And so she contracted serious ovarian cancer, late stage ovarian cancer, before it was detected, underwent surgery for that, and was not a plaintiff in the lawsuit because her cancer wasn't detected until afterwards. But the American Civil Liberties Union, which brought this case, was very interested in shaping public opinion as the case advanced from the lower courts through the appeals all the way to the US Supreme Court. And she played a very important role in that aspect of the case, even though she wasn't a plaintiff in it. So I'll read from the beginning of chapter 22. It's called Deja Vu All Over Again. All right, so Kathleen Maxian was smoking pot. Like a rebellious teenager, she was skulking in her own basement with a Tupperware bowl full of weed and a pack of Cheech and Chong rolling papers. It was for the pain, of course. 2 years after having her ovaries removed, Maxian's cancer had recurred. Now, in August of 2011, she was back on chemo, and the pain was hard to deal with. Her husband told her that it was okay to smoke in the living room or the bedroom or anywhere else she wanted, but somehow the basement felt right for this illicit medicinal ritual, which is why Maxian almost didn't hear the phone when it rang that afternoon. The caller wasn't her mother or one of her friends. It was someone she had never spoken with, but whose call she was expecting. Maxian's neighbor, Molly Hutton, was a genetic counselor at the Roswell Park Cancer Center in Buffalo, where Maxian was being treated. During her training, Hutton had been a summer fellow in Ellen Matloff's program at Yale. She had recently received an email from Matloff with the subject line, "I need stories." Matloff was looking for people who wanted to share their experiences with BRCA testing. Hutton immediately thought of her friend Maxian and told her about the call for volunteers. Maxian was ecstatic. When Matloff called Maxian that afternoon, it didn't take long for the two women to hit it off. Matloff knew all about BART. She had been one of the first people to realize that Myriad's standard BRCA test wasn't detecting all of the important BRCA mutations. Back in 2005, she had asked Myriad whether her lab at Yale could run additional BRCA tests on patients who tested negative under the standard BRCA test, but who had a strong suspicion of hereditary cancer. The company said no. Now, Matloff explained that the ACLU had brought a lawsuit to break up the monopoly that Myriad had on BRCA testing by challenging Myriad's patents. Maxian had heard about the lawsuit. When the news came out a couple of years ago, she had called her local ACLU chapter, but they never called her back. Matloff wasn't surprised. She explained that the litigation was being handled by the national office, and it was uncharted territory for most of the local ACLU chapters. It was a shame that they hadn't been able to recruit Maxian as one of their plaintiffs back in 2009. Matloff herself was a plaintiff, but there was a way that Maxian could help now. Matloff explained that the appeals court had just ruled against them, upholding Myriad's patents on the BRCA genes. It had also knocked out 19 of the 20 plaintiffs. Now the ACLU was appealing to the Supreme Court, but the Supreme Court hears only a tiny fraction of the cases that are appealed. So they needed to raise awareness of the issues nationally to show the court that the case was important enough to hear. They needed to make more noise than ever. Would Maxian help? Maxian's answer was clear and decisive. Hell yes. After that, things moved quickly. Maxian's story became the story, a new face for the ACLU's PR effort. She hadn't been diagnosed with ovarian cancer until July 2009, 2 months after the lawsuit was filed, so she wasn't a plaintiff. As a result, Maxian's story would not be tainted by standing and other procedural distractions. She could focus entirely on the impact of Myriad's patents and how they distorted the BRCA testing landscape so badly that her sister had not been offered the BART test that they both needed until it was far too late. The interview started almost immediately. Maxian's story was covered by news outlets from the New York Times to the oncology nurse. CNN interviewed not only Maxian, but her oncologist, her sister, and her sister's genetic counselor. Matloff called Myriad sleazy on live television. A scrolling headline at the bottom of the screen labeled Myriad's $700 charge for BART blood money, and Eileen sobbed, "I'm so mad at Myriad, it's even hard just to talk about it." They flew Maxian to New York, where she was interviewed by ABC and visited the ACLU offices. She was impressed by Sandra Park. Like so many others involved in the case, Park was a young woman, but she was making a difference. Maxian resolved that if she made it through chemo and ever became healthy enough to work again, she would do the same. No more installing corporate neon signs on buildings. She would do her part to help. 2 weeks before Christmas 2011, an ACLU camera crew rolled up to Maxian's home. She was nearing the end of her second 6-month chemo regimen, her hair still closely cropped in a style that loudly proclaimed cancer patient. The 4.5-minute video was titled "The Fight to Take Back Our Genes." It featured Maxian sitting beside a small Christmas tree in her living room, as well as stills with her sister and mother. Matloff played the talking head, explaining the science and the patents from a book-filled office. Shots of Myriad's patent and a cease and desist letter made appearances, as did a BRCA kit and a faceless lab technician pipetting fluid, possibly blood, into test tubes. Unlike the ACLU's earlier video, none of the lawyers made an appearance. The only mention of the lawsuit appeared in a series of text screens interspersed without commentary throughout the video. The US Supreme Court is about to decide whether a private company can own a piece of you. This is about women's health. This is about advancing science. This is about the fight against cancer. This is about the right to make informed decisions. This is about more than a court case. This is about taking a stand. The rhetorical impact of this message was substantial, yet it avoided the legal issues raised in the case. The omission was intentional. Were the video to conclude with the line, "This is about the product of nature doctrine and standing to bring suit," much of this impact would have been lost. In its appeal to the public, the ACLU needed to frame the case as a matter of women's health and civil liberty. The fine points of patent law would take a back seat in the court of public opinion. So that's the passage that I thought illustrates a lot of the important points made in the book.
So on that point, George, can you tell us a little bit, like, how did this case come to actually be before the US Supreme Court? So I think one thing that I often think about when I talk to non-lawyers is people think that, like, you just appeal and then you appeal, and then if you're not happy, you keep appealing, and you get to go to the Supreme Court at some point. But obviously that's not the case. And to get in front of the Supreme Court, it's really like a 1 in a million chance, right? Why did this case have the special sauce?
Yeah, exactly. It's about a 5% chance for cases that are not criminal and death penalty cases. But that's still not very much. So The case did raise a very important issue, and one that had never been raised before. You have to realize that by 2009, when this case was first brought, the US Patent and Trademark Office had been issuing patents on human genes for 25 years. It was considered well-established law that you could do this. And I'm happy to talk about the details of how that happened if you want. But everyone in the industry, academics, lawyers, scientists, and I'm among that group, we all just assumed that this was normal, this was a thing that you should do, even though these problems about the cost of this testing, the monopolization of markets for this testing were well known. We kind of thought it was unfortunate, but it's too bad that's the way it was. The ACLU, after 9/11 in 2001, the ACLU had an influx of cash from donations, and they doubled the size of their national staff. And one of the people they hired was a science advisor. They'd never had one before. And this person, Tanya Simoncelli, knew about genetics. She had been working at a nonprofit advocacy organization out in Berkeley that looked at genetics issues. And so when she brought to the attention of one of the senior lawyers at the ACLU the fact that companies were getting patents on these genes, he was shocked to start with. He didn't believe her for another thing, but she eventually convinced him that this was happening. And he decided that the ACLU should take on a case like this as a civil rights case, right? Not a technical patent case or a case, about the statute, but a civil rights case. And so that's how they litigated it throughout. They needed to show that the case was important, that it wasn't just about this one company's patents, but it was about all patents. By that time, by 2005, researchers at MIT counted and found that about 20% of all human genes had some sort of patent coverage, and more patents were being issued every year. And so this was something that they felt was an important issue that the court needed to look at. And in deciding what genes and what patents to challenge in their case, they were very deliberate in choosing patents that covered genes related to a disease that was very prevalent, right? There were lots of rare diseases whose genes were covered by patents, and terrible things were happening. Children were dying as a result of the patents that were not even being used for a disease called long QT syndrome. But you and I probably never heard of long QT syndrome before this, and most Americans hadn't either. But breast cancer, everybody had heard of. Justice O'Connor had breast cancer. The members of the Supreme Court all had been affected in one way or another by this disease, and this, I think, was important in really bringing it home to the court and deciding that they would hear this case.
Right, so much of this also, it is just, there's a marketing campaign, right, related to the litigation. What will, get people interested in the case, including the Supreme Court, which is human beings, right, 9 human beings making decisions.
The Supreme Court and their law clerks who play a very important role here. Mm-hmm.
That's true. So one thing I really like about this book, let me pause and say that you should go ahead and feel free to drop any questions you have in the Q&A to the attendees. So please feel free to go ahead and drop any questions you have into the Q&A, and we will incorporate them as they come up, or leave room at the end for more. So George, one thing I really like about this book is that it really highlights the difference between being a have and have not, right? So we talked about the op-ed where Angelina Jolie says everyone should get tested for this mutation. But as you note in this book, that's all well and good, but most people don't have the thousands of dollars to spend on this test. So talk to us a little bit more about that, the kind of the implications of this.
Right. So these patents became infamous because of the pricing of this test, right? Other genes that had been patented before this, the owners of those patents, whether it was the National Institutes of Health, University of Michigan, they basically let anybody run the tests, using the genes that they had discovered. The BRCA genes were the first ones that were patented by a for-profit company. And that made a difference because with a patent in the United States, you get the right, today it's 20 years, back then it was 17 years. for that 17-year period, you're the only one who's authorized to do anything with those patented substances, in this case with those genes. So this company, Myriad, was the only company in the United States that was allowed for 17 years to run tests to find these cancer-causing variants in the genes. And if someone wanted to test, they could charge whatever they wanted. It was a true monopoly, authorized under the law. We don't like monopolies, but patents are an exception to that rule, right? We allow limited monopolies, and we can talk about why. In any case, when we go to the doctor and get a cholesterol test or, the usual blood work that's done, it's not expensive. It's $75, $100 for, each of those lab tests. This test, Myriad did, some economic calculations and figured they could charge $3,000 roughly for their test. And they did, and there was nothing to stop them from doing that. Their goal, of course, was to get insurance companies to pay for that test. But at first, and for many years, most insurance companies weren't covering it, and especially Medicaid was not covering it. Medicaid said, we'll pay $1,600 for this test. And Myriad said, no, we will not take that. The price is $3,000, and that's all we'll take. If they dropped their price for Medicaid, then of course that becomes public knowledge, and then their contracts with big insurers, they would also have to drop the price, right? And they're a for-profit company. They would suddenly cut their profits in half, which they were not willing to do. So many people, especially people who didn't have, top-tier health insurance, were unable to afford the test. And so 6 of the plaintiffs in the case were women who had not been able to get tested, again, for one reason or another. And, that became a very big issue in the public eye, right? It wasn't, the pricing wasn't one of the patent law questions that the court actually had to decide. But I think it was very important in getting the Supreme Court to look at the case.
Yeah, and you're absolutely right. This idea that if Medicaid, if it's not covered under Medicaid, we're really cutting out the kind of a big segment of Americans who don't have private insurance, right? We're just saying if you're poor, you don't get this test. Sorry.
Yeah, that's right. That's right. I mean, there were a lot of weird things about this. So Kathleen Maxian, who I read about in that selection, she wasn't poor, and her sister wasn't poor. They could have afforded the test, but because of the deals that Myriad struck with the insurance companies wanted the test to be doled out as parsimoniously as possible, so they would have to pay as few times as possible for these tests. And so there were very strict eligibility criteria. And so you weren't even allowed to pay for the test in some cases, even if you could afford it, if you didn't meet those eligibility criteria.
Got it. Okay, so I'm very excited. We have an audience Q&A from Common House Book Club Q&A. I believe this is Common House. So Common House is a social club here in Charlottesville, and I think this is that Common House. But I apologize if I am getting you wrong, Common House. So Common House Q&A says, "Thank you, George, for so beautifully writing this story. As a fellow genetic counselor who has been practicing, as a cancer genetic counselor who has been practicing since 2008, I followed this case extremely closely and found many of Myriad's arguments to be quite compelling. From a legal standpoint, do you think the Supreme Court got it right?"
Well, so for those who are really interested in the legal arguments in the book, there's an appendix that I step out of the narrative mode and just go back into law professor mode and spend 30 or so pages telling you what I really thought about the opinion and the decision. I mean, at the end of the day, I do not think that human genes should have been subject to patent protection. There's a doctrine called the product of nature doctrine. If you are an herbalist, you go out into the forest, you find a new mushroom that nobody has ever seen before, and you bring it back, you can figure out that this mushroom is great for healing burns, or something else, and you can get a patent on a burn healing cream made with this mushroom. That's fine. I mean, some people might think that's not fine. I think that's okay. But can you patent the mushroom itself, right, as a new substance, a new composition of matter that you invented? The answer is no, you can't. Those types of patents, like, people do invent new substances, new compositions of matter, rayon, polyester, new types of carbon fiber, steel. Those are all created in a lab somewhere. And like the person who invented rayon, for 17 years, they were entitled to exclusive use of all uses of rayon, whether it's for clothing or rope or parachutes or whatever you're going to use it for. They're the only one. The one who finds the mushroom, no. You can't patent all uses of the mushroom, only some specific use that you find for it. Human genes were being patented as new substances, new compositions of matter. Why? Because when you take the gene out of a human cell, it now exists in a form that it doesn't exist in nature, right? In nature, in our cells, the genes are all strung together on these lengthy chains of DNA called chromosomes. There are thousands of genes on each chromosome. You pull, and I'm oversimplifying the science grossly here, but if you say, just figuratively yank one gene out of the chromosome, now you've got something that doesn't exist in nature. It's exactly the same gene that was sitting inside of each of our cells, but now it's isolated. And the patent office decided back in the 80s that you could patent a gene that's isolated as a new composition of matter. I think that was the wrong decision. And I think that the district court in New York actually had the most sensible opinion here, which is that, the function of a gene is really as an information carrying vehicle. The sequence of the nucleotides in the gene is what we really care about. And if it's the same sequence in the gene outside the body and inside the body, it's a product of nature. You should not be able to patent it. Now, the Supreme Court, this is a very long-winded answer, and I'm sorry, but so that part of the Supreme Court's decision I'm good with, but the Supreme Court also made a compromise, right? They gave a little bit, they threw a bone back to Myriad and said, but if you then take only the coding regions of the gene and string them together into something that you make in the lab, you can patent that. That is a little bit inconsistent with what they had said before about the gene that's plucked out of the cell, right? Either sort of chemical structure matters or it doesn't matter. I think it shouldn't matter in these cases. For most of the opinion, they say it doesn't matter, but here they say it does matter. So the piece of the opinion that relates to complementary DNA, cDNA, that's made in the lab, I also don't think that that should be patentable. But by and large, I think the decision was helpful.
So George, kind of one thing that law students learn about the patent system, along with copyright and trademark, is that they exist to incentivize innovation, right? So if I'm not going to be able to, if I have kind of the exclusive right to actually monetize my invention for a while, then I, am incentivized to tinker, and try to invent something cool. And a lot of my, especially, in the pharmaceutical space or in the med tech space, a lot of stuff I understand, you understand more than I do, but a lot of stuff fails, right? So I might have 10 streams of research, all very expensive, tons of, scientists, et cetera, and then all of them fail except for one. So we have to find a way to incentivize people to do this, or so the argument goes. So how do we balance this desire to incentivize innovation, and in this case, life-saving innovation, with the fact that, for every innovative thing that they actually come up with, there's, they're trying to cover the cost of 9 other things that failed.
Yeah, exactly. That's a perfectly legitimate argument. And, this argument is actually embedded in the Constitution itself, right? Article 1, Section 8, Clause 8 of the Constitution, which authorizes Congress to create a patent system, does it specifically to encourage the useful arts, right, and invention. And so this incentive function of the patent system it's the reason for our system. And you're right. And so I don't think that the ACLU, and certainly not I, are arguing that patents ought to be abolished altogether. But the question is whether you should allow patents on things that are simply found in nature, whether they're discovered or invented, right? I mean, so my point of view is that these aren't really inventions. So let's think about Myriad itself. Was the patent necessary to incentivize the discovery of the BRCA genes? The answer is, at least in this case, definitely not. When the rough location of the BRCA gene was discovered in 1990 by Mary Claire King, who was a researcher at Berkeley, that sparked off this international scientific race to find the specific location and the sequence of the gene. There were a dozen scientific groups around the world who were racing to do this. Myriad won the race. They were the only for-profit company involved, and because they were able to raise money through venture capital, through an alliance with Eli Lilly, were able to use good sequencing equipment that Lilly made available. They had some researchers who came from Caltech who actually had some pretty innovative ways of doing sequencing and gene discovery. They won, but not by much, right? Other teams were very close on their heels, and within a few months, another team, including probably the team that Mary Claire King was on, would have found the gene, the BRCA1 gene. With BRCA2, the gene that's more related to ovarian cancer, Myriad won this race by 1 day. 1 day. There was a group based in London, very prominent researchers there, who had already submitted a paper to Nature disclosing the sequence of that gene, of the BRCA2 gene. Myriad, somehow the Myriad researchers figured out that it was that Nature was going to release the paper on a Thursday, and they worked day and night to get their sequence of BRCA done, filed their patent application on Wednesday before the Nature publication came out, and they won that race literally by a day. And so the incentive argument really falls apart, right? That Myriad didn't need the patent. Somebody else was going to discover those genes. Now, there may be more obscure genes that, there was not a global race to find. And so maybe, yes, maybe patents would be helpful incentives. But actually, we have other incentives that get researchers to work on those types of discoveries, primarily federal funding in the United States. So Myriad, through the University of Utah, had significant NIH funding in its work. And the National Institutes of Health in this country, they fund $40 billion a year of biomedical research. Most basic discoveries in this country owe at least some of their success to federal funding. And so, at this very basic science level, where you're talking about products of nature, the incentive argument, it's there, but it's not essential, I think.
That's really, yeah, that makes a lot of sense to me. Now, I have another question from the audience. This audience member is Thomas Haley, and he says, great to see you. To what extent was this a patent issue versus a private insurance / for-profit focused pharma company issue?
Yeah, so technically, the issue before the courts was this narrow issue of the patent law product of nature doctrine. But the problem, right, really stemmed from a combination of the patent system with the reimbursement and payment system in the United States. So from Myriad's standpoint, they wanted insurance to cover their test, right? I mean, for them, the dream is for every man, woman, and child in the United States to have their insurance company pay for this $3,000 test. They weren't trying to withhold the test. They wanted the test to be given. The insurance industry is this very logical but somewhat sinister calculus in deciding whether or not to cover a diagnostic test. So this is a test for people who are well, right? It's not, it's not like you've got a fever and you're coughing and, we're going to give you a COVID test to see if you've got COVID-19. These are people who are healthy. Should they, should an insurer spend $3,000 plus to test them to see if they have these genetic mutations? Well, I mean, let's play through the logic if I've got a couple of minutes for that, right? So the logic kind of goes like this. I'm an insurance company, so I could pay $3,000 for this test. So what happens if the test is negative? Well, then I just wasted my $3,000. What if the test is positive, meaning you do have one of these cancer-causing mutations? Well, number one, even if you've got an 80% chance of getting breast cancer, which is what the risk is, this is a huge risk, but it's not 100%. So 20% of the people who tested positive, they're never going to get breast cancer. So I wasted my $3,000 on them too. So the 80% who are unlucky, who might get breast cancer, what are they going to do with that positive? Well, all 100%, because you don't know sitting there as an individual whether you're going to get cancer or not. What are you going to do? Well, you can do what Angelina Jolie did, which is a prophylactic bilateral mastectomy. If it's a BRCA2 or other mutation, you'll have your ovaries and fallopian tubes removed. And those will prevent you from getting these cancers. Those are expensive operations, and they're not risk-free operations. Every time you infection risks and so forth. So if I'm the insurer, I pay for the $3,000 test to see whether you're then going to get a prophylactic surgery that I'm then going to have to pay $50,000, $60,000, $70,000, $80,000 for. Okay, so I'm giving you a test to see if I should just pay more money. Now, sometimes that might make sense, right? Because we catch it early and so forth. But let's think about this. You're a young woman, you're in your 30s, and you take this test. Odds are that you won't develop cancer for a number of years. Well, suppose that you take the Myriad BRCA test, you walk out of the office and you get hit by a bus. Well, then, or I guess you get hit by a bus like the day after your expensive prophylactic surgery. Then we've wasted that money. We got we did the treatment before you got the disease. Or more likely than getting hit by a bus, you're going to change carriers before you develop cancer. People change carriers all the time. You change your job, or you end up on one of the federal programs, Medicaid or Medicare, and I wouldn't have had to cover your cancer, right? My coverage, the cancer, in fact, if you got cancer, all that I would have to pay is the money that I would have paid for that mastectomy anyway, because that's the treatment regimen. So you can see there are all of these convoluted, logical, but somewhat heinous, arguments that an insurer is going to make not to pay for this test. And so Myriad spent a decade negotiating with insurance companies to get them to cover the test, and eventually succeeded in getting most to pay for the test. But the trade-off was these very strict eligibility criteria. So they didn't have to test everybody. You had to have like 2 close blood relatives who were diagnosed with breast cancer at an early age, or 1 close first-degree relative with ovarian cancer. This is why Kathleen Maxian was never tested. Families. So let's go back to Utah. A lot of the research, a lot of the genetic research and genetic epidemiology done around breast cancer was done here in Utah, where there are big families, 2 families with lots of genealogical records that in some cases go back 7 generations. We know why these people died. what they died of, and how closely related they were to you. And so the assumptions in the care field were that, we can count. If you've got two sort of first or second degree relatives who had breast cancer at an early age, you're at risk, so you should get the test. But most Americans don't have that degree of genealogical records, and they don't have such big families. And so the Maxians, their parents immigrated from Italy, or I forget where, other countries. Who knows what, aunt somebody or other died of in Italy. And so it's hard to meet the eligibility criteria. Kathleen's sister, Eileen, developed breast cancer. But wasn't able to get this BART test from Myriad because she didn't have close first degree relatives who had other cancers. Then Kathleen developed ovarian cancer. It was only then that Eileen was eligible to get the BRCA test, which lo and behold, of course, she was positive, but only because her sister developed ovarian cancer, which she could have prevented if Eileen herself had been tested earlier. So the health payment and reimbursement system is very messed up. And I do place a lot of the blame there.
Yeah, I think that makes a lot of sense. And that brings up something that we actually hadn't talked about before, which is that, I remember being, I think in college or something, and going on one of these kind of genealogy websites. And like, there's nothing here for me. Like, my parents immigrated to the States in the 80s. Like, and I think that for those of us who have who don't have a long history of kind of tracking ancestry, right? Like, you just don't have a lot of information, right? Like, I don't know what my great uncle died of, like something not clear. And so there's kind of racial immigration as well as kind of the class lines on which this kind of stuff falls.
Yeah, exactly. One of the plaintiffs in the case, she is Asian or Asian American, and she joined the case specifically for that reason, to sort of represent the interests of immigrant communities who this information is just not out there.
So I'm going to pause for a second and invite any other kind of substantive audience questions before I get to some fun trivia questions of my own curiosity. So any fun any on-topic audience questions before the promised banter? Okay, so I have some questions for you, George, just because when the book came out, people put pictures of it on of them seeing the book on like airport shelves and all of that. I was just like, Jorge Contreras, like he had, that Jorge Contreras, like the guy who sat next to me at faculty meetings to whom I sent snarky texts, that one. So tell me a little bit about, I just want to get a peek behind the curtain of how a mild-mannered, nerdy law professor turns trade book author. So tell me a little bit about writing process. Like, how'd you get interested in the case? How'd you get started?
So, interest in the case is easy, right? Because I study patent law, and this case and the facts about Myriad and its patents, I knew about them long before the case was brought. And there's a small community of experts who know about patent law and genetics. There were some of us, and this was all very well known to us. When the ACLU brought its suit in 2009, that was just an incredible wake-up call. I would have said, like, wow, look at what just happened. No one except people who were involved was expecting this, because again, it had been 25 years, a whole generation where the patent office was issuing these, and we all thought, this is just happening. It's kind of too bad, but I guess it's not going to change. The ACLU brought this case, and to me, this was amazing. And then as the case unfolded, sort of year by year, I was obviously watching it, and I knew, a number of the people who were involved, and it just got, like, to quote Alice in Wonderland, curiouser and curiouser. At the district court, all of these quirky things happened, and the reaction from the patent bar was over the top crazy. Just these vituperative, like blog posts calling for the ACLU lawyers to be disbarred. There was a huge rift and a lot of emotion here. But when I looked around outside of this somewhat quirky, nerdy patent law community, no one really, knew much about this. So it finally gets to the Supreme Court. By the Supreme Court, there is some news attention. They had been on 60 Minutes. There are news crews outside of the court. There are people demonstrating outside of the court. And then this decision happens. But even after that, I talked to people about this, and like, you're educated people out there in the world still didn't know anything about it. And I thought to myself, this is an important issue. A lot happened, and it was just a really interesting story. More people should know about this. And, plenty of scholars and lawyers had written articles about this case at every stage, including myself. But, we all know how many people read law review articles. And, if you can count them on the fingers of two hands, you're doing pretty well. This seemed like a story that more people should hear about. And I knew they weren't going to learn about it through reading my articles. And there has been coverage in like the New York Times and other popular outlets, but those were news stories, like 250 words. And the story was just much richer and deeper than that. And so I thought, this has got to be a book. And I asked around and sort of asked the usual suspects, people who wrote about this, is anybody writing a book about this case? And the usual suspects said no. And so I thought, okay, well, if someone's going to do this, I'll do it. It'll be me. And, I tried to teach myself how to write a legal thriller / courtroom drama. I read a lot of John Grisham and Scott Turow and Michael Crichton. Footnote: Michael Crichton is actually in this book. He was a big advocate, a crusader against gene patenting. But Dan Brown, those sorts of books that have quick scene cuts, sort of quick character profiles that keep people's attention. I thought this is what we need. It's like the book A Civil Action, right? Back in the 90s, about the toxic contamination case in Woburn, which this was part of my inspiration. My law firm that I worked at in Boston was involved in the case. It appears in A Civil Action, and a number of my former partners and colleagues appear in the book. One of them was played by Robert Duvall in the movie. And so, I always had in the back of my mind, like, it'd be kind of fun to write a book like that normal people could appreciate, even though they're complicated legal issues.
I definitely did get those vibes, right? I actually, as I was reading the book, talked to some of our former shared colleagues and was like, did you know that George wrote this thriller about patents? And yeah, that's it. Yeah. So we do have a real question again from Common House. So the question is, there is a vocal group, Mary Claire King included, pushing for more population-based testing. Do you have thoughts on that after hearing your criteria thoughts?
So my view of the world is that more information is better, like always. And so I totally agree with Mary Claire King, who also appears in this book, who I interviewed for this book, was very generous with her time. Population-based screening, why not? Why not? The testing today is much cheaper, right? So in 2013, the Supreme Court did strike down these patents, and testing immediately dropped in price. And today, 23andMe for $125 will give you your BRCA variant results, at least for the top variants. And I see no reason why everybody shouldn't be tested. The pricing, I mean, believe me, I wouldn't go get a surgery on the basis of my 23andMe test. I would definitely want to go to an accredited laboratory before that. The pricing is still expensive and many people can't afford it out of pocket. So I do think, the insurance industry still needs to loosen up. the criteria. I mean, there were lots of reasons behind the criteria beyond simply insurance companies not wanting to pay. Early on in the field of genetic cancer testing, the bioethics community raised concerns that people, women in particular, were just not going to be able to handle the information. You know, and so we shouldn't give it to them. It was,
well, we have women, as you know, are very, you know, very small brains, etc.
It's a classic paternalistic attitude. I mean, this is why, you know, for many, many years of human history, doctors would like tell wives' medical results to the husbands and not to the wives. Right, again, which I find appalling today, but you know, shaped, I think, a lot of our practice. And there were papers about whether people who got this information would freak out, whether they would commit suicide as a result of finding out that they were positive for some of these mutations. That didn't happen. You know, we learned that most women are sensible. You know, if they get tests like this, they won't get the test that they want to know, but if they do, they're not going to freak out. And so I think we've gotten past that. But the eligibility criteria were created back in the 90s when that was still a mode of thought that had some influence in the field.
Yeah, and I agree with you. I mean, for the record, that is a sarcasm in the previous sarcasm is when I said women have trouble. But I mean, I think there's a real challenge, I think, in you know, how much information to give patients, right? Like, and whether, I mean, more like there's now more like patient advocacy, that patients should have transparency and the ability to know information about themselves. Mm-hmm. All right, so we're kind of getting low on time. So any final questions? And then I have a final question for you, George. So of personal interest, this book has both Washington connections and Salt Lake City connections. And I just found it very interesting, like having driven past to the Myriad headquarters so many times. And you've spent obviously a lot of your career both in Washington and in Salt Lake. So tell us about traveling, like the process of traveling between these places and working on this book. Like, which celebrities did you see on the plane as you traveled back and forth? Tell it all, spill it all in this recording that will never go away.
Yes. You know, I started working on this project when I was teaching at American University in Washington, D.C., which is where I spent much of my practice career and whatnot. We moved to Utah sort of in the middle of that in 2014 for reasons totally unrelated to this book. And, you know, as professors, we start a bunch of projects all the time. We don't finish all of them. I probably wouldn't have finished this project if we hadn't moved to Utah, because when we moved here for this book, Salt Lake City and the University of Utah were a gold mine. I think I was able to get excellent access to people who probably would not have spoken with me if I were just calling from American University in Washington, D.C. You know, I was able to interview and speak at length with like the venture capitalists who backed Myriad, with Myriad's founders, with a number of the scientists who are my colleagues at the university now. And I was allowed to rummage through like all of the old archives and records that were just sitting around at the Department of Genetic Epidemiology. So really amazing stuff. On the Washington side, this was one of those things where, you know, you just keep going down that rabbit hole, and like what you find out, you just can't believe it. I knew that the Obama administration had been interested in this case. The Solicitor General, of course, submitted an amicus brief, and they were the ones who came up with this compromise that Justice Thomas ultimately went with in the decision. But how did they get to that decision? I made FOIA requests to like a dozen different agencies. I talked to a lot of people, a lot of former administration officials, which was the key, and some people who are still in the administration, but it's the former ones who are most willing to to talk and spill the beans. I had a very fortunate FOIA fail by one agency that, I mean, I don't know if you've ever done a FOIA request. Most of what you get are big stacks of paper that, you know, they have a line at the top that says redacted under section XYZ, and then the rest of the paper is just blacked out or just white because they've cut everything out of it. I got a number of pages, stacks of these pages from one agency who will remain nameless, that said at the top it had the legend, information redacted under section XYZ, and then they forgot to redact the information. And so
now someone's getting fired, some intern's gone.
That was extremely helpful. But I found that I was people, even very senior people in the administration, were willing to talk to me. I joke there are only two people who didn't return my calls. I mean, one was Barack Obama, who does appear in this book and played a role in this, but never was able to get through to him, even though, like, seriously, we were law school classmates. Even so, never returned my calls. And the other one was
just rude. I mean,
rude. At the next reunion, he is going to hear about this. And Angelina Jolie, who you also mentioned, I definitely wanted to talk with her, and no response.
Also rude.
I thought so. She's undoubtedly, she's regretting it. You know, I even paid time for permission to use the cover photograph of her in the book. So if you know, those who listen to the audiobook don't know this, but there is a photo of Angelina Jolie on the cover of Time after she made that announcement that Cathy mentioned.
Well, I did listen to it via audiobook. I will say that the audiobook, what is the correct word? Actor? Narrator. Did a fabulous job. He did not describe the pictures, but I will go back through the book and make sure I look at the picture for like 1 to 2 minutes so you get your money's worth. But I was also proud of the audiobook author for pronouncing your name George, which I know is your preference. So good job, narrator.
Well, I made a pronunciation guide for the narrator. Just given all of the scientific and other terms in here, I wanted to be sure. You know, how would you know that you say that you spell out the gene BRCA, but you say CRISPR for CRISPR? You know, if you're not a scientist or somebody, you wouldn't know that. But anyway, so yes, so he did a good job. We also, you know, I thank him too out there. We did pick him. The audiobook publisher does give you a few narrator choices to choose from, and you get to hear some sort of promo tapes of theirs. And he definitely, my sister, my wife, and I all agreed he was the one who should narrate this book.
Well, he did a great job and reading this excellent book. So it's time for us to wrap things up. So thank you so much to George, and for everyone who tuned in. Please consider buying the book from your local bookseller or through the links on vabook.org. You can also check out future festival events and watch past events at vabook.org. So thank you so much, George, for taking the time to chat with us about your fabulous, fascinating, important book. And I hope if you all haven't had a chance to read it, that you will read it or listen to the excellent audiobook version.
Thanks so much.
Thank you.